and welcome everyone. In this video, we would discuss 5 landmark Supreme Court judgments on freedom of speech and expression in India. But before we delve into the topic, we would first try to understand what is this right to freedom of speech and expression? Is it an explicit or an implicit right given in the Indian Constitution? And the concept of reasonable restrictions upon the rights granted to us. So, firstly, to answer the first question, what is right to freedom of speech and expression? Freedom of speech and expression denotes the authority or entitlement to express personal opinions devoid of censorship, restrictions, or legal repercussions. The unrestricted exchange of ideas within a public space is fundamental to a liberated society and requires constant protection. Thus, individuals have the liberty to voice their thoughts through spoken words, writing, printed material, visual representations, or any other medium. This freedom also encompasses the right to disseminate or publish the viewpoints of others. So, we understand that the right to freedom of speech and expression is the right to be able to express your ideas and opinions devoid of any fear of any kind of curtailment, and the expression can be in spoken form, written form, printed material, or in any sort of visual representation. The expression can be in various modes, and in every mode we are free to express ourselves as long as we do not violate certain conditions that we would understand in the concept of reasonable restrictions. So the basic idea is that people have the right to free speech and expression. Now we would deal with the second question, that is it an explicit or implicit right? In India, the assurance of freedom of speech and expression finds its foundation in Article 19(1)(a) of the Constitution. So it is an explicit right mentioned in the Constitution. However, there are also guidelines internationally concerning this freedom, that such as the Universal Declaration of Human Rights, the European Convention on Human Rights and Fundamental Freedoms, the International Covenant on Civil and Political Rights, etc. All these international agreements also focus on this right of freedom of speech and expression, and in the context of India as well, this is an explicit right as it is mentioned in the Constitution of India in Article 19, Clause 1, Subclause A. However, Clause 2 of the same Article 19 specifies that the freedom mentioned in Subclause A of Clause 1 is not absolute and allows for the enactment of laws that reasonably restrict its exercise. These restrictions can be imposed in the interest of upholding India's sovereignty, state security, amicable relations with foreign relations, maintenance of public order, decency, morality, contempt of court, defamation, or incitement to an offense. Now, all these are the grounds that are mentioned in Clause 2 of Article 19 that permit restrictions on this right to freedom of speech and expression. However, all these terms, decency, morality, contempt of court, are very subjective, and thus the courts play a very important role in determining what is violative of decency, morality, contempt of court, and what are the boundaries of these words. What is the accurate definition? This is determined from case to case basis, that what would be considered reasonable restriction and what would be considered unreasonable. So hence, Clause 2 specifies that there can be reasonable restrictions, but what is reasonable is determined by the power of the courts in India. So it is important that we understand the landmark judgments in India so that we can further comprehend the scope of Article 19 and the right to freedom of speech and expression, and how long can it be and to what ambit can it be extended. So now we would move on to the landmark judgments in this scenario. The first case we have is Romesh Thapar versus the State of Madras 1950. In this case, the petitioner published and distributed a newspaper called Crossroads, which critically reviewed and appraised the schemes and activities of the Madras government. The Madras government imposed a ban on the entry and circulation of this newspaper within the state, citing public safety concerns as ground for restrictions. The Supreme Court ruled that the authority for the circulation of the newspaper lies solely with its establishment, namely the company producing the newspaper. The state of Madras does not hold the right to intervene in this matter. Additionally, the court highlighted that using public safety as a basis, as outlined in Article 19, Clause 2, does not constitute a reasonable restriction. Therefore, the ban imposed by the state of Madras on the entry and circulation of the newspaper was deemed impermissible under Article 19, Clause 2. So, in a nutshell, in this case, the petitioner published a newspaper critically reviewing a few of the government schemes, and so the government consequently banned the circulation of the newspaper. But the court lifted the ban, saying that the state of Madras does not have any right to intervene in this matter because the ground that the government cited, public safety, is not mentioned in clause 2 of Article 19 as a reasonable restriction. So the court in this case identified the restriction as unreasonable, and the freedom of speech and expression was upheld for the petitioners, as they could express themselves thoroughly through the newspaper even though it was critical of the government scheme. So, with this, we move on to the next case, that is Bennett Coleman and Co. versus Union of India. The citation is AIR 1973 SC 106. In the case of Bennett Coleman and Co. versus Union of India, the petitioners Bennett Coleman and Co. contested the constraints imposed by the import policy on newsprint under the Import Control Order of 1955 and the Newsprint Order of 1962. The subsequent newsprint policy of 1972 and 73 introduced further limitations, including restrictions on established newspaper companies starting new newspapers if they already own two, with one being a daily newspaper, and imposing maximum page limits on newspapers. Moreover, the policy prevented substantial increases in the number of pages for smaller newspapers and prohibited the exchange of newsprint between papers of the same company or different editions of the same newspaper. The petitioners, even within their allocated quota, were unable to make necessary adjustments, leading to their challenge under Article 19, Clause 1, Subclause A of the Indian Constitution, which guarantees freedom of speech and expression. The Supreme Court maintained the maintainability of the petitioner's case, emphasizing that being a company did not preclude granting relief for violating the rights of shareholders and staff. The court clarified that Article 358 invoked by the respondents could not be applied to laws passed before the emergency proclamation. The court underscored that freedom of the press is an integral component of Article 19(1)(a) and that the absence of explicit mention as a distinct category was inconsequential. Furthermore, the court criticized the imposition of quotas as a viable solution to newsprint shortages, but found the direct interference in setting page limits and similar regulations as irrational and unjustified. Restricting the number of pages in a newspaper could force establishments to curtail content or reduce advertisements, leading to economic hardship and ultimately limiting freedom of speech and expression. Consequently, the court declared the newsprint policy of 1972 and 73 is unconstitutional, ruling in favor of the petitioners, upholding their right to freedom of speech and expression. Then we move on to the third case, that is Hamdard Dawakhana versus Union of India. In the case of Hamdard Dawakhana versus Union of India, the issue revolved around advertising prohibited drugs and commodities. The petitioners marketed a product claimed to possess self-medicating properties, promoting it to the general public. The petitioners faced obstacles due to objections raised against their advertisements. The Supreme Court ruled that an offensive advertisement cannot be considered within the ambit of freedom of speech and expression. The court delineated an advertisement termed as commercial speech, focusing on two aspects. The first being advertising being a commercial transaction primarily disseminates information about a product, and number B, it serves the public interest by making product information available through advertisements. From another perspective, the court emphasized that the general public holds a right to receive this commercial speech. Freedom of speech and expression not only guarantees Article 19(1)(a) not only guarantees freedom of speech and expression, but also safeguards an individual's right to access and receive such communication. Consequently, advertisements promoting prohibited drugs were deemed beyond the purview of Article 19(1)(a). So the court basically said that the public has a right to commercial speech and to receive advertisements, but the advertisement cannot be offensive. If in the name of commercial speech for commercial transaction you are advertising something that is harmful and prohibited, that is causing harm to the greater public, then that cannot be considered as a advertisement, and you are not free to advertise something that will cause greater harm to the society. This was upheld by the court for the greater good of the society. Now we move on to the next case, that is Prabha Dutt versus the Union of India. In this case, the Srimati Prabha Dutt, the chief reporter of Hindustan Times, filed a petition invoking Article 32 of the Indian Constitution. She sought a writ instructing the respondent, the superintendent of Tihar jail, to permit her to interview two convicts, Billa and Ranga, sentenced to death under Section 302 of the former Indian Penal Code. Their petitions for clemency had recently been rejected by the President of India. The Supreme Court in this instance directed the superintendent of Tihar jail to allow representatives from select newspapers to interview the two convicts under Article 19(1)(a). The court underscored that the right granted under that article is not absolute, nor does it confer unrestricted access to information mediums upon the press. So the court held that this right does not give unrestricted access to media houses to reach anywhere and to interview anyone. But in this case, the court gave permission to certain newspapers, select newspapers, to interview the two convicts that the petitioner Srimati Prabha Dutt wanted to interview. So here the permission was granted, but the court gave an obiter remark that this right does not inherently mean that it is absolute and all the press people have an absolute liberty to interview anybody, but permission can be granted from case to case basis. And now we move on to the last case, that is the Indian Express newspaper versus Union of India case. So in this case, before a particular notification, newsprint enjoyed exemption from customs duty. The petitioners contested the imposition of import duty on newsprint as per the Customs Tariff Act 1975 and the additional duty under the Finance Act 1981. This was modified by a notification under the Customs Act 1962 from March 1, 1981. They argued that post this notification, costs and circulation were significantly affected, severely impacting freedom of expression and the freedom to pursue any trade or occupation as guaranteed by the Indian Constitution. The Supreme Court of India in this instance highlighted that though the Indian Constitution doesn't explicitly state freedom of the press within Article 19, it is encapsulated within the spirit of Article 19(1)(a). The court emphasized that interference with the freedom of the press under the guise of public interest is impermissible. It stressed that the press's role is to serve public interest by disseminating facts and opinions, pivotal for informed decision making in a democratic society. Therefore, it is incumbent upon the courts to protect press freedom and invalidate any laws or administrative actions conflicting with this constitutional mandate. Thus, we get to see how the courts play a very important role in determining what is permissible and what is not permissible under the are under the freedom of right to freedom of speech and expression. Here, the court upheld the freedom of press and criticized that the government cannot interfere in the freedom of press every time under the name of serving public interest, because the press should essentially perform its job of disseminating facts, pivotal for informed decision making. So this is a spirit of a democratic society that diverse voices should flourish, and the court upheld this rationale to justify that the freedom of the newspaper should be upheld and the interference was unreasonable. So it is upon the court's discretion to decide what is reasonable and what is unreasonable. This much is clear from the five cases that we read today. And now we will just conclude today's discussion, because we understand that through its judgments, the Supreme Court interprets the scope, limitations, and the protection of this fundamental right, ensuring its proper application within the country's legal framework. In conclusion, we can say that the Supreme Court's pivotal rulings on freedom of speech and expression have fortified the bedrock of democratic principles in India. These judgments have not only safeguarded this cherished right, but have also paved the way for a robust, informed, and participative democracy, underscoring the indispensable role of free expression in shaping India's societal fabric and governance. With this, signing off, Vidisha Banerjee. Thank you.